any other students out there from another class?
Not yet.
Not yet? Okay.
Good morning, Your Honors. Adam Kravitz, appearing for Dean Ryber, the appellant. So first, I'd like to reserve 5 minutes at the end.
Yes, sir.
For rebuttal. So my client has appealed an order of the Circuit Court dismissing his claims solely on the ground of forum nonconvenience. Before getting into the key legal issues, I want to make clear that the background to this case is simply that a United States citizen and resident has chosen to sue a United States citizen and resident in her home county, in her home state,
And your client is a resident of where now?
El Paso, Texas.
But he also filed in Belize, correct?
Correct.
So does that make a difference? I mean, does that truly show your choice, your client's choice of forum was in Belize? Because I believe the trial court relied on that in their determination. So should that make a determination, or should that make a difference in the determination?
No. First of all, we argued that that is, first of all, it's a different argument. It's pendency of a prior action, not forum nonconvenience. Okay, simply because the plaintiff may have filed a case in Belize does not make it necessarily more convenient or less convenient for the defendant getting sued to defend the case in Florida.
So for the purposes of this argument today, is it fair for us to assume that there was no action filed in Belize and just limit ourselves to whether a suit here in Brevard County should be dismissed for forum nonconvenience when a Texas resident sues a Brevard County resident?
In all candidness to the, not quite, I would concede one thing, because I did in the brief. I don't think it makes much of a difference, because I don't think there were any facts at all in the case, because they never filed an affidavit. And that really just ends the analysis there, because they simply didn't support their motion with
There should be some
at all.
deference to your client's preference under Cortez of where he would like to file, correct?
Yes, and he filed in Florida. I mean, that's
But I guess, again, goes back to the trial court also said that he filed in Belize, but you said that shouldn't make a difference.
It shouldn't make a difference, except, and the one concession is in the first step of the Kinney analysis. So I'll kind of grant that if the trial court can say, look, you can't say that there's not an adequate and available forum because you filed in Belize, maybe there's some merit to that. Now, I, in my brief, say there's really not a lot of merit to that, because they didn't. There's many reasons you could file first in Belize and find out it's not an adequate or available forum at all. You can find out that you can't transfer your judgment. You can find out it's any one of multitude of reasons. Okay, but what I would say is, other than the adequacy and availability under the very first step of Kinney, you still have to get through the rest of Kinney. Okay, maybe there's an argument there, but simply because you file in Belize or Iran or Nicaragua or wherever, okay, it doesn't mean that Ms. Yamasaki is inconvenienced. Cortez is very clear that a United States plaintiff, okay, is accorded great deference in their forum choice, and the forum choice in this case was Florida. Okay, that's going to be the forum choice in every forum nonconvenience argument in the state of Florida.
Well, would it have been fair for the trial judge to say, well, if I deny the motion of the defendant to dismiss under forum nonconvenience, then still I will technically have two identical lawsuits, or two lawsuits going forward on the same set of facts, and we ought not to have that. That should be something to avoid, not having duplicative pending litigation, right?
Well, first of all, I didn't choose the defendant's motion, and I didn't choose the defendant's arguments. This is the arguments that they brought to the table. They brought forum nonconvenience. They also argued about privacy, comedy, and some other things, but the trial court never even reached that. So I can't argue against things that are not.
Right. I mean, we're limited to the the basis of the forum nonconvenience. That's what the judge denied or dismissed the case on, even though there were other issues raised in the motion. Right?
Okay, but the second thing, and the record is clear because I said it in the hearing, so it's that that we said we would dismiss, we agreed to an order. There, unfortunately, and I apologize to the court for this, but it's the way things go, there was actually two written competing motions. The trial judge said, excuse me, orders. The trial judge said go back and draft your order. And we drafted that. That's not part of the record because it wasn't ever filed. It was just emailed back to the judge. But we said, and we said in the hearing, that we would agree to the dismissal of the Belize case if the court in Florida dismissed the motion.
So can the judge do that? Can the judge enter an order that says, I'm going to deny the Rule 1.061 motion to dismiss filed by the defendant, but I'm only doing that conditioned upon you as the plaintiff's counsel within X number of days filing a dismissal of the Belize action?
Well, that's what I wrote. I certainly wouldn't have appealed it. Okay.
Well, what lawyers write and what the authority, that doesn't always matter.
I don't see why the judge can't. Well, I think because it's a pendency, again, it's not really a convenience argument. It's a pendency argument.
No, but could the judge say, look, I have this motion from the defendant saying, you already have a suit pending that you filed first in Belize, and now he says you got that, plus you got the form nonconvenience. Here's how I'm going to wrap this all up as the trial judge. I'm going to deny the motion to dismiss for form nonconvenience because I, as a trial judge, don't understand how it's inconvenient for a Brevard County resident to defend herself in Brevard County from a suit by an American citizen. But I want to wrap this up. I want to make sure you dismiss the Belize action so there's not two things going. So the judge has the, I know you write it. Does the judge have the authority to do that?
Yes, and I'll tell you why I think why. Because what we asked for was a stay. So in any event, we would have to come back. If we got a judgment in the foreign country, we would still have to collect on it in the United States. You would still have to start a lawsuit here and domesticate the judgment in the United States. So therefore, and that's the Prescapo case, I believe there was the Brazilian case. Bring it up on my rebuttal. But there was a Brazilian case which we argued that said, look, the Brazilian case said, look, the proper remedy is to stay the case because you're going to be back here in Florida anyway. Okay, so yes, the answer is that the case is stayed until you dismiss the
Well, let's take it. All right, so if we buy your argument here and we say we're going to reverse, and we write something that says we're reversing, but that's only conditioned upon you dismissing the Belize action, so we do not have duplicative actions pending.
I wouldn't have a problem with that.
All right, well, you're not having a problem and us having the authority.
I don't know why they.
And I know that sounds silly, but you may or may not be surprised. We have a lot of discussions internally about what we can or cannot do vis-a-vis our jurisdiction preservation and anything else that Judge Boatwright can think about. So.
Well, I before going back to my planned speech, I would say I would kind of answer that by saying that the big question that I think the court should consider is why I don't have a problem with it. Why would the defendant have a problem with it? Why would the Brevard County resident have a problem with litigating the case in their home county? I was fully prepared for the question of why did you file in Belize in the first place? Not my client. And my answer is, well, why are they objecting when in their brief, when in their motion, she clearly stated that it was more difficult for her to litigate in Belize than it was in her home county.
That would seem to be self-evident for both of you, I would say.
I don't know our response to that. Okay. So, in any event, however, I think I would like to point out that what they are really arguing here is that because the tort happened in a foreign jurisdiction, although the complaint, and I want to make this clear, the complaint clearly argues that clearly states that the damages are ongoing and psychological damages and so forth, and that's obviously occurring in the States because he's in the States.
Going back to you said that there was no sworn testimony below or affidavit.
Yes,
so
that's right.
So that's required by our court. Correct?
That's correct.
Not by the rule itself doesn't have any of that type of language, correct?
The rule itself does not have that type of language, but
our court does.
But it does say that the burden of the proof is on the movement. Okay, and this is a fact. If you look at Kinney, it's obviously a factual analysis. You cannot weigh the private factors, where the witnesses are, all of this. This is all
there an exception to the sworn testimony?
They state that the exception is, well, to be quite honest, there's a lot of agreement on the law here. I'm not arguing that their exception, the exception if it's in the face of the complaint.
Did the judge go outside the four corners?
Clearly.
Okay, how did he do that?
Clearly, okay. The complaint, first of all, the complaint is simply alleges a tort that happened, the physical tort in Belize, and then the damages that flow from that. Okay, and what they're really saying is that simply because it happened in Belize, okay, that somehow this on its face, prima facie, creates a situation where it's more convenient to litigate it in Belize. This is obviously not the law.
Is that a public interest factor, though? So the trial judge in Brevard County says, why is it, assuming this goes to a jury trial, why do I have to have citizens of Brevard County sit and listen to a case involving a fellow who lives in El Paso, Texas, who said he got injured in Belize? Why shouldn't Belize hear the case? Why should we? Because Brevard has nothing to do with it other than the defendant happens to live here, and she says, I don't want to be in the lawsuit here.
Well, I've said and I've cited in the brief that the state of Florida, well, I want to answer the question on the private interest.
You like that one better?
I do like that one better, but I'll take yours.
Probably better questions. Yeah.
But the state of Florida has an interest in hearing cases involving its own citizens. Okay, it's not, as I said in the brief, it's not like 110%, but the courts are fairly clear on that. Okay, but going back to the private interest, remember, Kinney is a sequential step. What the trial court judge said, he wrote, step 2, private interest. All of the evidence concerning the ownership, possession of the location where the incidents occurred in Belize. That's not in the complaint. I mean, there's no allegation in the complaint as to where evidence concerning ownership and possession of the location is. Okay, even if it's even relevant to a tort complaint, I'm not quite clear why that's even relevant. But access to evidence, relevant sites, and access to witnesses are in Belize. That's outside the complaint. Simply because a tort happens in Belize doesn't mean all the witnesses are there. In fact, Mr. Ryder isn't. In fact, and to be quite honest, this kind of goes when I was thinking about this. Her cousin that held the rock over his head is actually in the United States now, okay? And I didn't mention that either at the hearing or in the briefs, and the reason that I didn't is because there's nothing for me to argue against. There's no sworn testimony. There's no witness list. These are the witnesses that we're going to bring, and this is their importance, and this is why it's inconvenient to have this case in Florida and more convenient to have it in Belize.
The defendant should have then added to the motion or added an affidavit to the motion and saying, here's the witness cousin. He lives in Brazil, or he lives, to put it in the record so there's an evidentiary basis for the judge to say, oh, okay, it happened in Belize. The perpetrator. The cousin's Belize, so he's going to be there. The officers are in Belize, and
that's correct. You're saying that the defendant, the moving party,
the moving party,
they have to file. They have to support it. It could be live testimony. It could be an evidentiary hearing, right?
Well, the judge has to have the trial judge in ruling on the motion has to have an evidentiary basis to grant it, and there's no evidence here other than the stipulation that it did happen in Belize because that's on the face of the complaint.
Exactly, and that's clear. The law is crystal clear, black letter law. If you're filing a motion under forum nonconvenience, it's the moving party's burden, and the moving party must support it with facts. And the only way to support it with facts, with evidence, is to file an affidavit, have live testimony. Something. There was nothing here other than attorney supposition. And just to go on the step 2 paragraph, duplication of process in Belize will double the expense of the litigation. Now, where was that in the complaint? How do we know how much more or less it is going to cost to try the case in Belize? There was no evidence on that. Just pulled out of thin air. Okay? And then plaintiff has not contended that a mechanism for a fair trial does not exist in Belize, nor could he, since the plaintiff elected to file suit in Belize first before Florida. a fair trial has nothing to do with step two, okay, that's more step one. And again, there's the main part of step two is the great weight under Cortez that is supposed to be given to the plaintiff's choice of Florida as a forum. And Cortez is very clear that a burden is on the defendant to show that there's manifest injustice in hearing this case in Florida. And I don't see how you do that when you can't even file a sworn affidavit.
You're in your.
Okay, and I'm into my rebuttal.
Good morning, gentlemen. Good morning. Mark Peters for the appellee in this case, Yamasaki. Let me start out by explaining a little bit about why there was no affidavit or testimony. At the time my motion was filed, at the time this hearing was held, there were 3 pending cases in Belize involving these same parties, 2 civil, 1 criminal. So we looked at the complaint that was filed in this case, and I can recite the paragraphs for you and what was specifically alleged in the complaint, which would be deemed as true for the purposes of our hearing. I also attached to our motion to dismiss a copy of the lawsuit, the civil lawsuit that was filed about these identical incidences, because I expected, and in fact happened, that my opposing counsel would acknowledge there would be a stipulation on the record that there was a prior case involving the identical incident with very similar allegations that had been filed before the case was filed in Belize.
Same causes of action?
Very similar, Judge. There were a couple, because there were 6 causes of action filed here. I don't think there was a civil conspiracy case filed in Belize. But it's part of the record, and its part was attached to our motion to dismiss. So rather than risk somehow causing problems for the 3 cases pending in Belize by sworn testimony here, and the risk of somehow incriminating my client in the pending criminal case in Belize, there was a conscious decision made not to do anything as far as filing an affidavit or presenting live testimony in order not to cause problems with the criminal case in particular because of the very specific allegations that were contained in the complaint. So let me run through those for just a minute. There's an allegation, paragraph 11, that there was a condo purchased in Belize, and in paragraph 12, that the parties lived together in that condo until July of 2022. That the plaintiff in the case changed the locks in September, that my client broke into the condo in Belize. There was an assault, that's in paragraphs 15, 16, 17, and 19 and 20 of the complaint. In paragraph 21, that the police entered into the condo, that they questioned the 2 parties that were there, including my client. There was an arrest in Belize. Paragraph 23, that there's a trial pending in Belize concerning the arrest, and that there was suffered severe injuries, and that there was mental injury attached to the attack in Belize, and that the plaintiff had suffered business losses and serious and extreme damage. So we go in with an acknowledgement that there's prior pending suit, and we go in with those allegations deemed to be true. If you look at Kenny, and as Cortez kind of alters it, the first, is there an adequate and alternative forum? The court could very well find there was an adequate and alternative forum because the plaintiff in this case made the election to file a lawsuit in Belize before he filed a lawsuit in Brevard County.
If there were no action pending in Belize, could the forum nonconvenience argument survive?
Yes.
How in the world?
It would require evidence and, I'm sorry, I interrupted.
No, go ahead.
It would require, in that case, it would require evidence and proof of what availability there was to seek redress through the Belize court system. We didn't need to do
So is it your argument he's obligated to proceed in Belize?
No. It's my argument that because it is self-proved by his filing a complaint in Belize that there was an alternative forum. Because he got service on it, which is one of the keys under Kenny is the defendant available for service in that alternate forum? And there was no issue that there was not a pending lawsuit.
So let's assume, arguendo, there is no action pending in Belize.
Yeah.
How,
No. I did.
I'm sorry?
Ever.
Ever.
It had never been filed.
Let's assume it doesn't exist.
Yes, sir.
Then how is it conceivably inconvenient for a defendant to defend against a cause of action in her county of residence? That's
Let's talk about that. So we have in the complaint an allegation of severe injury. The court could infer there was medical care as a result of a severe physical injury that occurred in the location where the injury occurred.
But again, our court has said there needs to be some type of evidence, sworn testimony, and now you're saying the court can infer.
They can infer from what we know to be proven as a fact that there was a severe physical injury, because that's what was alleged, and for the purposes of a motion to dismiss, that is true. So the court took that as true. There are allegations in the complaint that we know that are true, that there was police involvement. There was an arrest.
Well, let's talk about medical care. Can you come back to Texas, Florida, anywhere else and got medical care?
Yes.
Okay. So those witnesses would be there.
Not in Belize.
Wherever they occurred. Not in Belize, in Texas, or wherever else he got medical care. True. Think about, we're going to get into this, the other issue. What's the nexus between the Florida court and these events? What's the nexus between the Florida court? I mean, we're talking about, if I'm trying this case, because if you reverse this case, I'm probably going to be the one that tries the case. How do I subpoena or get evidence from Belize concerning the events that occurred? How do I compel witnesses to testify either remotely under our new systems or come here to testify in a trial of this case? Am I taking depositions
What if
in
your
Belize?
opponent had simply dismissed the Belize suit 3 days before your hearing?
It still doesn't disprove whether there's an available alternative form.
So what you're saying and then is that, you dismissed it, but you need to go back and refile because I, as a defendant, don't want to be sued in the county where I live across the street from the courthouse.
My argument is that the court here could still say this was an inconvenient form.
To the court, pretty much, isn't it? Where you're saying there's no nexus to Brevard County other than the defendant lives there. And so,
Correct.
And there's a strong presumption that we talked about in court, or the Supreme Court talks about in Cortez, that United States citizens should have the benefit of suing in the United States, especially when they're suing a defendant in the residence where she lives.
But it's not a presumption you can't overcome.
It's when they say it's a really, really strong one, then I share Judge Saud's incredulity, if that's the right word, as to why I would think I'd be happy to say, thank goodness I don't, and as you kind of comment in the motion, look at how it's going to be so troublesome for me to go to Belize. It's expensive. Yeah, that's where you say you want to go because...
Well, that gets into the whole secondary step of what is the inconvenience between the parties? Where's the evidence? Where are the witnesses? For instance, if you're sitting as a judge in this case...
Let me answer. Okay, the witnesses. You're not arguing. There is no evidence in front of the trial judge, but setting that aside for a second. All right, so the witnesses are the plaintiff, the defendant, the cousin, so maybe I'll give you, he's a police guy. The officers, they're not going to come in and say, well, I arrested somebody about this. I would think that you would want to exclude them coming in to testify that my client was arrested for committing this act that she's now being civilly sued.
Are there police photographs of the crime scene? Are there police photographs of any injuries to the plaintiff in the case? Are there written statements or recorded statements? Are there video statements that you would take?
You might win on that at the trial, though, but you didn't present any of that. You didn't present any sworn testimony of that, don't you?
I didn't need to because they talked about the police action that happened in Belize.
in the complaint.
In the complaint. They talk about the police coming into the room in the allegations. There are allegations
Let
concerning...
me ask you about the private interest factor that he stated. The judge says all of the evidence concerning ownership, possession of the location where the incident occurred is in Belize. Is that outside of the complaint?
There are 2 paragraphs that make allegations concerning the purchase of the condo by the plaintiff in the case and the fact that the parties resided together in the condo. There are allegations about the plaintiff changing the locks to the condo, and there's allegations about my client breaking into the condo.
Okay. What about the statement the judge made in his order, access to evident relevant sites and access to witnesses or Belize? Is that in the complaint specifically?
I don't think it's specifically in the complaint. I think the judge could infer that from what the allegations are, just as you can from any other evidence that's presented to a trier of fact.
I mean, but you keep using inferring. So if the plaintiff comes in and says, I didn't get any medical care in Belize, I didn't go there, I left the state the next day or the country the next day. And so the judge's inference is not supported, but that's one of the bases that you're saying was a correct ruling on the dismissal.
It is.
Okay.
It is. Do you have any other questions for me?
No, sir.
Thank you very much.
Thank you.
I'll rest on our brief.
Okay, thank you.
Your Honors, I don't have much to say, but I would like to say this. First of all, when you talk about what was in the complaint, as he just quoted, medical damages, it's just as easily to infer that, and I have to digress on a personal story here very quickly, because I don't have much time left. 2 years ago, I slipped and fell on the steps of a hotel in Hanoi, okay, Hanoi, Vietnam. Okay, I have the scars on my ankle to prove it. I got casted up and suffered through the rest of the vacation because it was a family vacation, came back to Miami and was operated on in Baptist Hospital. Where are the witnesses? There's no basis.
How's your suit going in Hanoi?
Well, it was my fault. I slipped. A long story, and I don't have the time. But that's kind of the point. Okay, the point is that simply because that, and just to be clear, the cousin is American. He left Belize and came back to the States. But there's no reason simply because an accident happens in one place that the medical treatment is going to happen in that place, let alone the long-term medical treatment. We talked about psychological damages. We talked about business losses. The plaintiff is a U.S. citizen with his business in the United States, okay, which we know is not in the record, but why would we presume that his business is in Belize? Okay, there's a lot of inferring going on here. The reality is that and finally, I would add that this whole concept of relying on the facts of the complaint is extremely rare. Okay, in fact, the appellee was only able to really find one case really where it happened, which is ground improvement. Okay, and even in that case, the court said it barely happened, and they didn't really give any guidance. They didn't say, oh, this is what a complaint has to allege for us to go out to find an exception to the rule that they have to support the facts with sworn testimony. Okay, it doesn't really say that, but what I will say is that what it did say was the facts were uncontested, uncontroverted. Okay, and here the question of where the witnesses happened, where the ease of getting to these witnesses are. Okay, you know, and as I raised at the hearing, what is going to be the more important issue in the case? And you know, I would often talk that liability can be easy, but damages is hard. Okay, where the meat of the case was, I said, look, the meat of the case is in the liability. I don't think there's really going to be a lot of issues over what actually happened in Belize. Okay, I think there's going to be a lot of issues as to what happened to what the witnesses, the medical witnesses, the business loss witnesses, etc., are going to testify in the United States. And to wrap it up, I would say that again, going back to this issue in Cortez, that a U.S. plaintiff is supposed to be given great weight as this forum choice in Florida. What about the plaintiff? If the case is in Belize, we're going to have to ship doctors and business loss testimony. So everything that the defendant says about trying the case, how easy it would be to try the case in Belize, I'm not really clear why it's easy for them. I'm not even clear how that evidence is going to help them, to be quite honest. Okay, because there's no testimony. The judge didn't really examine the witnesses. He didn't say, oh, this witness, how is this witness helping?
I know they have the burden, but do you have a requirement to bring in testimony also? Because you didn't present any testimony, correct?
I don't believe, I don't believe that we can argue. It's their burden, and they have the argument to make the case, and I can't guess what they're going to say. I can't guess which witnesses they're going to say is important. I can't guess what they're going to say needs to be testified on. And I think that's really placing an undue burden on the defendant. If I knew what I was arguing against, then we could argue against it. And at that, we would, again, request that that this court reverse the trial court's decision and remand it. And to be quite honest, I would not be opposed to having to dismiss the case.
Thank you. Thank you both of you. Well-argued case.
Yeah, all right, gentlemen, you saw what happened earlier. If you guys want to talk briefly, Ms. Kravitz,